My ex-husband called me 10 years after the divorce. I need your help. I didn't answer. But a week later, his lawyer called. Ma'am, your husband has passed away and left you $77 million, but there is one condition. Good day, dear listeners. It's Diana again. I'm glad you're here with me. Please subscribe to my channel and like this video. And also let me know in the comments which city you're listening from. That way I can see how far my story has traveled. I never kept his number in my phone. After the divorce, I deleted it the same afternoon the papers were signed. Not out of spite, not out of drama, but because I had learned, at great cost, that some doors needed to stay closed. Daniel Hartwell had been my husband for 11 years. He had also been, in ways I only understood clearly after he was gone from my life, a man who treated people as instruments. You were useful to him or you were not. For most of our marriage, I had been useful. Then I had not been. That was 10 years ago. By the time my phone rang on that ordinary Tuesday morning in October, I had built something I was genuinely proud of. My interior design studio, Meridian & Co., occupied a bright second-floor space on Wicker Park's main stretch in Chicago. I had 3 full-time employees, a wait list of clients, and a reputation for taking on projects that other designers considered too complicated. I ran 6 miles every morning along the lakefront. I had a good therapist, a rescued greyhound named Pepper, and a small circle of friends who had known me through the worst years and stayed anyway. My apartment on Damen Avenue was full of things I had chosen for myself, not because a man approved of them, but because they made me feel at home in my own life. I was 44 years old. I was, for the first time in a long time, genuinely content. So when my phone buzzed and the screen showed a number I didn't recognize, a 312 area code, Chicago, I almost didn't pick up. I was in the middle of reviewing fabric samples for a client in Lincoln Park, but something made me pause. I stared at the number for 3 rings, then let it go to voicemail. The voicemail was 42 seconds long. I played it twice standing at my design table, the fabric samples forgotten. Sarah, it's Daniel. I know this is unexpected. I know I have no right to call, but I need your help. Please call me back. It's important. His voice was quieter than I remembered, thinner. There was something in it I couldn't immediately name. Not manipulation, which I knew the texture of intimately, but something closer to fear. I stood very still for a moment, listening to Pepper shift on his bed in the corner. Then I set my phone face down on the table and went back to work. I want to be honest about what I felt in that moment because I think it matters. I didn't feel triumph. I didn't feel vindication. I felt something more complicated, a low, familiar pull toward concern, the reflex of 11 years of marriage, and underneath it, a firm, clear resistance. I had spent too long learning to trust that resistance to override it now. Whatever Daniel needed, there were other people in his life. He had remarried within 2 years of our divorce. He had a brother, Marcus, who had always been his closest confidant. He had an entire ecosystem of advisors and associates who orbited his business empire. He didn't need me. I didn't call back. For 6 days, I almost forgot about the voicemail entirely. Almost. The truth is that it sat in the back of my mind the way an unread letter sits on a desk. Present, slightly weighted, easy to ignore until it isn't. I went to work. I met with clients. I ran my miles. I had dinner with my closest friend Karen on Thursday, and I thought about telling her about the call, but didn't, because I knew what she would say. She had watched me rebuild myself after that divorce. She was fiercely protective of the version of me that existed now. The call I couldn't prepare for came the following Monday. I was at my studio, coffee in hand, when an unfamiliar number rang. A 202 area code this time, Washington. The man on the other end introduced himself calmly, professionally. "Ms. Caldwell, my name is Richard Cole. I'm a partner at Hargrove & Cole, attorneys at law. I'm calling regarding the estate of Daniel Hartwell. I'm very sorry to inform you that Mr. Hartwell passed away 11 days ago. He suffered a cardiac event at his home in Georgetown." I sat down. The office around me, the fabric boards, the light flooding in from Wicker Park's October sky, Pepper asleep on his bed, all of it suddenly felt very far away. "I wasn't aware," I said carefully. "We understand," Richard Cole said. "We've been attempting to reach you through several channels. Mr. Hartwell's personal call to you was, in fact, part of this process. He knew he was ill. Ms. Caldwell, I'm calling because you are named as a primary beneficiary in Mr. Hartwell's will. The bequest is $77 million. The number landed in the room like something physical. "And," Richard Cole continued, his voice unchanged, professional, "there is one condition attached to the bequest. Mr. Hartwell was very specific. To receive the inheritance in full, you must agree to serve as the sole executor of his estate, including the establishment and oversight of the Daniel J. Hartwell Charitable Foundation, for a period of no less than 6 months." I looked out the window at the October street below. 6 months, $77 million, and Daniel's entire world, including, I would soon learn, people who would not welcome me there at all. "I'll need time to think," I said. "Of course," Richard Cole said. "But Ms. Caldwell, you should know that there are other parties with interest in this estate. Time may matter." I didn't sleep that night. I sat in my apartment on Damen Avenue with a cup of tea that went cold, Pepper's head on my knee, and my laptop open on the coffee table. Outside, Chicago was doing what it does in late October. Wind off the lake, leaves stripped from the trees on the street below, the city settling into its long gray season. Inside, I was trying to think clearly about something that felt, every few minutes, like it might swallow me whole. $77 million. I typed Daniel's name into the search bar and read for 3 hours. The obituaries were substantial. Daniel Hartwell, 61 years old, had built a real estate and private equity firm out of a small inheritance and a ruthless instinct for undervalued assets. By the time he died, Hartwell Capital had interests across 7 states and 2 foreign countries. The obituaries were respectful, carefully worded in the way that wealthy men's obituaries tend to be, full of professional achievements and short on the kind of truths that don't get said until much later. He was survived by his wife, Victoria Hartwell, née Sinclair, 38 years old. His brother, Marcus Hartwell, 56, a co-founder and managing partner of Hartwell Capital. No children. I looked at Victoria's photograph for a long time. She was striking. Dark hair, the kind of groomed, expensive confidence that comes from years of practice. I knew almost nothing about her. After the divorce, I had made a deliberate choice not to follow Daniel's life. It hadn't been easy in the early years, but it had been right. Now I was looking at the woman who had replaced me and trying to understand what it meant that Daniel, knowing she existed, knowing what he had left $77 million not to her, but to me. What had happened in that marriage? And what, exactly, was Richard Cole warning me about when he said time may matter? The next morning, I called my own attorney first. Ellen Marsh had handled my divorce a decade ago, and she was the kind of woman who thought 3 steps ahead and told you what you didn't want to hear when you needed to hear it. I drove to her office in the Loop before 9 a.m. and laid out everything Richard Cole had told me. Ellen listened without interrupting. Then she asked several pointed questions. Then she sat back in her chair and looked at me steadily. "Sarah, as executor, you would have legal authority over the administration of his entire estate. That means you control the distribution of assets. You oversee the establishment of this foundation, and you have fiduciary responsibility for any assets not yet transferred. Do you understand what that means in practical terms?" "I think so." "It means," Ellen said, "that Victoria Hartwell, as the surviving spouse, may have expected to control this process, and Marcus Hartwell, as a co-founder of Hartwell Capital, likely had his own expectations about what happens to the company assets referenced in the estate. If Daniel bypassed both of them entirely and named you as executor, those are two people who are going to be very unhappy." I had already understood this in abstract. Hearing it plainly made it concrete. "What's the risk to me if I accept?" I asked. "Legal challenges to the will, challenges to your fitness as executor, personal pressure, possibly worse depending on what these people are like." I looked out Ellen's window at the gray Chicago skyline. What were these people like? I didn't know Victoria at all, but I had known Marcus Hartwell for 11 years of my marriage, and I knew him well enough to understand that he was, beneath a surface of expensive ease and old boy charm, a man who believed rules applied to other people. He had never liked me. He had made no particular secret of it. When Daniel and I divorced, Marcus had been openly pleased. The thought of going up against both of them, a widow with legal standing and a brother with insider knowledge of every company asset, was genuinely frightening. But $77 million was not nothing, and Daniel, whatever his many failures, had chosen me, specifically me. Out of everyone in his life at the end of it, he had picked up the phone and called me. He had written my name into his will with a condition that only I could fulfill. I needed to understand why, and I needed to make sure that whatever he had intended, it happened the way he intended. "I want to accept," I told Ellen, "but I want to accept properly. I want to understand every clause of that condition before I sign anything." Ellen nodded, and I saw in her expression something that looked almost like respect. "Then we start by requesting the full will and all estate documentation from Cole's office today. Before you sign a single piece of paper, we know exactly what you're walking into. And we find out," I said quietly, "what Marcus and Victoria have already done with those assets since Daniel died." That was my first plan. It was simple. It was careful. And it was, I would learn, already too late to be entirely innocent, because by the time I began asking questions, there were answers someone very much did not want me to find. Richard Cole's office was on K Street in Washington, which told you something about the kind of law his firm practiced. I flew down on a Wednesday, Ellen beside me, the full text of Daniel's will printed and annotated in my carry-on bag. I had read it 4 times on the flight. It was 63 pages long. The language was dense and precise in the way that only documents drafted by very expensive lawyers can be. But the core of it was clear. I was named sole executor. The $77 million bequest to me personally was contingent on my completing the executor role, the establishment of the Daniel J. Hartwell Charitable Foundation, the final distribution of estate assets, and a certified accounting of all transactions conducted in the 90 days prior to Daniel's death. That last clause was the one I kept returning to. A certified accounting of all transactions in the 90 days prior to death. Why would Daniel specify that? Why build it into the condition of my inheritance? It was not a standard executor requirement. Ellen had flagged it immediately. He wanted someone to look, she said. He was telling you to look. Richard Cole was a tall man in his late 50s, silver-haired with the particular stillness of someone who had spent decades in rooms where very large amounts of money were being negotiated. He shook my hand across a conference table with a view of the Capitol dome in the distance, and I noticed, just briefly, that his handshake was slightly firmer than necessary, the kind of firmness that is actually a test. I met it evenly. "I'm prepared to formally accept the role of executor," I said, pending our review of the full estate inventory. Richard Cole nodded. He passed a folder across the table. "We anticipated that. This is the current inventory of estate assets. I should inform you, Ms. Caldwell, that Mr. Hartwell's family has already been in contact with our office." "Victoria," I said. "Mrs. Hartwell, yes, and Mr. Marcus Hartwell. They have expressed interest in the will's disposition." He paused. They were both surprised by its contents. I imagine they were. I signed the documents that afternoon. Ellen witnessed them. As I set down the pen, I felt something shift in my chest. Not quite fear, not quite excitement, but the particular heightened awareness that comes when you understand that you have just stepped across a line and the ground behind you is already closing over. Back in Chicago 3 days later, the estate's digital financial records arrived in a secured portal, as requested by Ellen. We had retained a forensic accountant, a woman named Dr. Patricia Osei, recommended by Ellen, meticulous and quiet, to begin the 90-day transaction review. Patricia called me on a Thursday evening, 10 days into her work. "Sarah," she said. She rarely used my first name. "I need you to come in tomorrow. There's something you need to see." I arrived at Patricia's office at 8 a.m. She had a large monitor on her desk covered in spreadsheets, and she walked me through them methodically, the way she did everything. Without drama, without flourish, the numbers doing all the speaking. In the 60 days before Daniel's death, while he was ill, while he was, as we now knew, already preparing his will, a series of transactions had been conducted through Hartwell Capital's operating accounts. 12 separate transfers ranging from $800,000 to $4.2 million moved to 3 separate holding entities. The holding entities had been established 9 weeks before Daniel died. The registered agent was a law firm in Delaware. The beneficial owner of all 3, once you followed the paper far enough, was Marcus Hartwell. $11,300,000 moved in the weeks before Daniel's death, without any documented authorization from Daniel himself. "Is this illegal?" I asked, though I already knew the answer from the cold, certain feeling in my stomach. "It's potentially fraudulent asset transfer," Patricia said. "If Daniel didn't authorize it, and there's no documentation suggesting he did, then Marcus moved company assets that should be part of the estate inventory into entities he controls privately. That means those assets are currently not appearing in the estate, which means they'd be excluded from distribution." "And from my accounting," I said. "Yes." I sat with that for a moment. "What about Victoria?" I asked. "Is she connected to these entities?" Patricia clicked to a new screen. "One of the 3 entities, the smallest, has a secondary beneficial owner." She pointed to a name. Victoria Sinclair Hartwell. They had done it together. While Daniel was dying, his wife and his brother had quietly moved $11 million out of his estate into entities only they controlled. And they had done it assuming no one would ever look carefully enough or be legally empowered enough to find it. They hadn't counted on Daniel knowing exactly what they were capable of. They hadn't counted on him leaving the keys to someone who had no reason to be merciful. I drove home through Chicago's evening traffic with my hands steady on the wheel and my mind very, very calm. The fear was still there. It had not left since the moment Richard Cole first said Daniel's name. But beneath it was something new, something that felt, if I'm honest, a little like purpose. I had the evidence. Now I needed a plan that was airtight enough to survive whatever Marcus and Victoria were about to throw at me. Ellen filed the petition on a Tuesday morning. It was a formal motion to the Cook County Probate Court requesting an emergency freeze on the 3 holding entities Marcus had created, on the grounds of potential fraudulent transfer of estate assets. Patricia's documentation was attached. 40 pages of transaction records, entity filings, and annotated timelines. It was not an accusation. It was, as Ellen carefully explained, a precautionary legal measure to preserve estate integrity while the executor conducted her authorized accounting review. Clean, professional, entirely within my authority. By 3 that afternoon, Marcus Hartwell had called my cell phone 7 times. I let every call go to voicemail. Ellen had advised it. Anything they said to me directly without counsel present could only create problems. But I listened to the messages that evening, standing in my kitchen with Pepper pressing against my leg as though he could sense the tension in the room. The first 2 messages were controlled, almost polished. Marcus's voice had the measured authority of a man accustomed to being obeyed. Sarah, this is Marcus. I think we need to have a conversation before this gets out of hand. Call me. By the 4th message, the Polish was thinning. You have no idea what you're doing. Daniel was not in his right mind when he made these arrangements. We have documentation. You are making a very serious mistake. The 7th message was left at 11:47 p.m. Listen to me carefully. You are not going to win this. Pull back now and I'll make sure you receive a reasonable settlement. Something fair. Keep going and you'll find out what this family is actually capable of. Don't test me, Sarah. I played that one twice. Then I forwarded it directly to Ellen. The threat, once documented and in the hands of my attorney, was no longer a threat. It was evidence. Victoria made her move differently. She appeared in person. I was leaving my studio on a Friday evening, Pepper on his leash, the October air biting and clean, when a black car pulled alongside me on the sidewalk and Victoria Hartwell stepped out. She was even more striking in person than in photographs, composed in that weaponized way of very beautiful, very controlled women. She wore a camel coat and heels on uneven pavement and did not stumble once. Sarah, she said, as though we were acquaintances running into each other at a gallery opening. I think we should talk. You can contact my attorney, I said, and kept walking. She walked alongside me, which took nerve, I'll give her that. I understand you're angry. You have reasons to be. But you're being used right now. Daniel used you his entire life, and now he's using you from beyond the grave. What he's asking you to do is going to consume 6 months of your life and put you in legal crosshairs. And at the end of it, even if you succeed, what do you have? Money you'll spend defending yourself to get. I stopped. I looked at her directly for the first time. What he's asking me to do, I said, is what executors do, which is what I'm legally authorized to do. Your husband made his wishes very clear. Something moved behind her eyes, a flash of something harder than the composed surface. The foundation was a sentimental idea from a sick man. Marcus and I can make this much simpler for everyone. Walk away. Accept a payment of $2 million for your time, and we handle the estate ourselves. $2 million, as opposed to 77, as opposed to also ensuring that $11 million in stolen assets was returned to the estate for proper distribution. No, I said. I walked away. She did not follow. The following week, Marcus's attorneys filed 2 motions challenging my fitness as executor. One citing lack of financial expertise, one citing alleged personal conflicts of interest stemming from the divorce. Both were, as Ellen explained with barely concealed satisfaction, thin. The court denied the fitness challenge within 4 days. The conflict of interest motion was scheduled for hearing, but in Ellen's assessment, had minimal grounds. They were throwing paper at me. Legal paper costs money and time, but it was not substance. It was pressure. And then, on a Thursday evening, I received an email to my studio's business address. No sender name, generated address, clearly disposable. It contained a single attachment, a photograph. It was old, blurry, taken at some kind of social event. It showed me in conversation with a man I recognized, a former client, someone I had worked with professionally years ago, who had later been investigated for tax issues. The implication was obvious. The photograph proved nothing, but in the wrong hands, framed the wrong way, it could be made to look like something. "This is what we have," the email read. "Imagine what else we can find." I forwarded it to Ellen. I called the FBI tip line, not because I expected immediate action, but because I wanted it documented. And then I closed my laptop, sat on my kitchen floor, and let myself feel, for about 15 minutes, genuinely afraid. Then I got up, fed Pepper, and booked a long weekend in Door County. I had earned 3 days of lake air and silence. Whatever came next was going to require me whole. Door County in late October is almost empty. The tourists are long gone, the summer colors stripped back to bare birch and dark water. I rented a small house right on the bay. Nothing fancy, just clean and quiet, with a wood-burning stove and a porch that faced west. Pepper spent 2 days running on beaches that were entirely gloriously ours. I slept 9 hours a night. I read a novel I'd been meaning to finish since August. I cooked actual meals and ate them slowly, at a table, without looking at my phone. On Sunday morning, I sat on the porch with coffee and watched the bay change light for almost an hour without thinking about Marcus Hartwell or Victoria or forensic accounting or probate courts. That was the whole point. I have always believed that there is a difference between running away and stepping back to see more clearly. Door County was the latter. By Sunday afternoon, when I packed the car and Pepper jumped into the passenger seat with his particular Greyhound dignity, I felt something I hadn't felt in weeks: steady. The call came on Tuesday, the day I returned. Not from Marcus this time. From Victoria's personal attorney, a woman named Constance Webb, whose reputation Ellen had already briefed me on. Sharp, strategic, and known for settlements. The fact that they'd brought in Constance meant they were shifting tactics. "My client would like to offer a revised arrangement," Constance said. Her voice was professionally warm, careful. "Mrs. Hartwell recognizes that this process has been difficult for all parties. She's prepared to offer a cash settlement of $10 million in exchange for your resignation as executor and a mutual non-disclosure agreement." $10 million, not $2 million, as Victoria had offered on the sidewalk. A significant increase. A significant increase signals, if you're paying attention, that they have significant reason to want you gone. "I'll pass the offer to my attorney," I said. "Ms. Caldwell, Sarah, I want to be candid with you. The legal proceedings ahead are going to be lengthy. There will be discovery. There will be depositions. There will be months of your life given over to this process. $10 million is a real and fair offer. Think about what your life looks like on the other side of this, either way." It was a good speech. I could tell she meant it, at least professionally. She was giving me genuine advice wrapped in her client's interests, which is about as honest as that situation gets. "I'll pass the offer to my attorney," I said again. "Thank you." I hung up and sat for a moment at my studio desk. 10 million was not nothing. The voice of fear, the one that never entirely goes away, pointed out that 10 million was enough to never work another day, to travel, to give money away freely, to build an entirely different life. The voice of fear said, "You could take it and be done." But the fear voice did not have access to the full picture. It didn't know about those $11 million that Marcus had moved into his private entities. It didn't know that those entities were funded by money that, in a properly administered estate, would have gone partly to employees with pension contributions, partly to creditors, partly to legitimate heirs. It didn't know that Daniel, whatever his flaws, had, at the end, tried to do something right, and that the only thing standing between his last wishes and two people who had already stolen from him was me. I called Ellen and declined the offer formally. Then I did something I should have done 3 weeks earlier. I asked for help. I drove to Karen's apartment that evening with a bottle of wine and told her everything. Karen sat across from me at her kitchen table and listened without interrupting, which is one of her great gifts. And when I finished, she was quiet for a moment. "So," she said, "what do you need from me?" "I just needed to say it out loud," I said, "to someone who isn't being paid to hear it." She nodded. "Then I'm saying it back to you. You're doing the right thing, and you're going to get through this, and I'm here for every part of it." I called my sister Diane in Minneapolis the next morning. Diane and I have had a complicated relationship our whole lives. She's 5 years older, more cautious, quicker to counsel retreat. I expected her to tell me to take the settlement. Instead, she surprised me. "Daniel called you," she said, "out of everyone. He was dying and he picked up the phone and he called you. That has to mean something." "I think it means he knew I'd actually look," I said. "Then look," Diane said simply. Patricia and I had lunch that week, not a work meeting, just the two of us, soup and bread at a quiet place near her office. I had come to respect her profoundly in a short time. She was the kind of person who cared about accuracy the way some people care about justice. Personally, almost morally. "How are you holding up?" she asked. "Better than I expected," I said honestly. She nodded, stirring her coffee. "They're going to come at you harder," she said. "Before this is over, it'll get worse. Just so you know." "I know," I said. She looked at me evenly. "Good. Then we're ready." Around me, quietly, without drama, my circle had formed. Ellen with her legal precision, Patricia with her numbers, Karen with her steadiness, Diane with her unexpected faith. 4 women, and a greyhound who pressed against my legs every night as though to say, "You are not alone in this." I was not. They came together, which surprised me. I had expected another lawyer's call, another formal offer through proper channels. What I had not expected was the two of them standing at the glass door of Meridian and Company on a gray November morning, coats on, faces arranged in expressions of civil concern. My assistant Jess looked at me across the studio with a question on her face. I told her to give us the conference room. Marcus was 66 years old now, but carried himself as though age was something that happened to other people. broad-shouldered, silver-templed, with the particular ease of a man who has spent his whole life moving through rooms where he was automatically considered important. He sat down without being invited to. Victoria sat beside him. She had toned down the armor for this visit, less polished, more softened. A cashmere sweater instead of a structured coat. Her hands folded on the table like a woman who has come in good faith. They were very good. "We appreciate you making time," Marcus began. "We know this situation has been adversarial, and that's not what any of us wanted." I said nothing. I had learned, years ago in my marriage, that silence is a more powerful response than almost anything else in a room with people who are performing. Victoria leaned forward slightly. "Sarah, I want to be honest with you. I know Daniel and I hurt you. The way things ended, I know I'm not innocent in that. And I think we're both being held hostage right now to a situation that Daniel created out of, I don't know, guilt or some idea he had about setting things right at the end." She shook her head. "But this isn't setting anything right. It's putting 3 people through a legal nightmare." 4, Marcus said, "because if this goes to full discovery, my attorneys have made clear it gets expensive and ugly for everyone." There it was, wrapped in concerned language, the same threat Marcus had left on my voicemail. This will get ugly, this time delivered in person, in a sweater, with eye contact. "The foundation," Victoria continued, as though Marcus hadn't spoken, "was something Daniel talked about for years and never actually moved on. It wasn't a real plan. It was an idea, and an idea shouldn't cost all of us months of litigation." "What are you proposing?" I asked. Not because I was considering anything, but because I wanted to hear exactly how they had decided to present it. Marcus folded his hands. "We've spoken to our attorneys. There's a path forward that doesn't require the current escalation. You resign as executor. A professional fiduciary is appointed, mutually agreed upon. The estate is settled through standard probate procedure. You receive a settlement of $15 million. Clean, fast, done by spring." 15 million. The number had climbed from 2 to 10 to 15. The trajectory was its own information. I looked at Marcus. I looked at Victoria. I thought about $11 million moved through Delaware holding companies in the weeks a dying man was writing his will. I thought about a photograph sent to my email from a disposable address at 11:30 at night. I thought about Daniel, who had many flaws, who was not a good husband, who had not been an easy man to love, picking up the phone when he was dying and calling me. Not Victoria, not Marcus, me. "No," I said. Marcus's expression didn't change immediately. He held the pleasant, reasonable look for about 3 more seconds. Then it slipped. "Sarah." His voice had dropped into something lower, something without the veneer. "You are not equipped to handle what's coming. You are a woman who runs an interior design business. You don't understand what you've stepped into. Daniel put you in this position because he was sick and angry, and he genuinely thought, that it was clever. It wasn't. It was cruel. To you." "I'm sure you believe that," I said. "You should take the 15, Victoria said, and for the first time, her voice had no warmth in it at all. Just the flat fact of a woman who wanted something and was tired of not getting it. "Is there anything else?" I asked. There was a silence in the conference room that lasted about 5 seconds. Then Marcus stood. He straightened his jacket with the particular deliberateness of a man recalibrating. "You're making a mistake," he said, "and it's going to cost you things money can't replace." They left. I watched from my studio window as the black car pulled away from the curb below. For a moment, I won't pretend otherwise, I felt the cold finger of genuine fear. Not the legal kind, not the financial kind, the personal kind. The kind that lives in the part of your body below your ribs and doesn't respond to reason. Marcus Hartwell was a man who had moved $11 million in secret while his brother was dying. He was not someone whose threats were empty. But here's the thing about fear. When you've spent long enough sitting with it honestly, it can be a compass. The fear told me exactly how much the truth mattered to them. The harder they pushed, the more certain I became that what Patricia had found was only the surface of something larger. And the more certain I became of that, the less I was willing to walk away. I went back to my desk. I called Ellen and told her what had just happened, every word, and then I told her it was time to move to the next phase. The hearing was set for the 3rd week of November. I drove to the courthouse alone that morning. Ellen had offered to pick me up, but I wanted the 30 minutes in the car to myself. The familiar streets of Chicago sliding past, the gray lake visible between the buildings, the city doing what it always does, indifferent and ongoing. I thought about the first time Daniel and I had driven through this city together 20 years ago, both of us new to Chicago. Both of us thinking we understood what we were building. I thought about how little we had known. I parked in the structure on Clark Street and sat for a moment with my hands in my lap. You know what you're doing, I told myself. You've done the work. The courtroom was not dramatic in the Hollywood sense. Probate court rarely is. It was a room of fluorescent light and wood veneer and papers, presided over by Judge Miriam Alonso, a small woman in her 60s whose reputation, according to Ellen, was for patience and absolute intolerance of nonsense. The gallery was sparse. A few other cases waiting their turn, Marcus and Victoria's legal team across the aisle, and in the row behind me, quietly, Karen and Patricia. I had not asked them to come. They had simply appeared. Marcus had hired Aldrich Crane, one of Chicago's more expensive probate litigators, a man who specialized in making complexity feel insurmountable to the opposing side. He began with a procedural challenge to the relevance of the forensic accounting, arguing that the 90-day transaction clause in the will was ambiguous in its scope, and therefore the accounting could not serve as the basis for any court action. Judge Alonso listened. Then she asked Ellen to respond. Ellen laid out 4 pages of case law in 12 minutes, precise, sourced, organized in ascending order of relevance to the exact language of Daniel's will. She did not raise her voice once. When she finished, Judge Alonso thanked her and denied the challenge without deliberation. Aldrich Crane moved to his second argument, and his third. Each one was met by Ellen's preparation, each one disposed of cleanly, until I could see across the room a subtle recalibration happening in Marcus's posture. The ease was becoming effortful. Then Patricia took the stand. She testified for 2.5 hours. She walked through the 12 transactions methodically. She showed the entity creation dates, 9 weeks before Daniel's death. She showed the wire transfer records. She showed the beneficial ownership filings. She showed the gap in authorization documentation. No board resolution, no signatory approval, no correspondence from Daniel or any Hartwell Capital officer authorizing the transfers. $11,300,000, moved without authorization, currently sitting in entities controlled by Marcus Hartwell and in part by Victoria Hartwell. How confident are you in these findings? Ellen asked. The documentation is complete, Patricia said simply. The transactions occurred. The authorization does not exist. Aldrich Crane's cross-examination was aggressive, Patricia's credentials, her methodology, the forensic software she used, the possibility of incomplete records. Patricia answered every question with the same unhurried precision. She did not get flustered. She did not overreach. She simply knew what she knew and said it plainly. Then Marcus was asked to testify. This was, I think, the moment. He entered the witness box with his usual authority, and it held for the first 20 minutes. He offered explanations. The transfers were part of an operational restructuring plan, a plan he had discussed with Daniel, a plan that was always intended to be formalized retroactively. It was, he said, a common practice in private equity. Ellen's cross-examination took 35 minutes. She asked about the board meeting minutes documenting the restructuring plan. There were none. She asked about any correspondence, email, text, written, in which Daniel had approved or been informed of the plan. There was none. She asked about the law firm in Delaware that had established the entities, Marcus's own personal attorney, not Hartwell Capital's counsel. She asked about the timing. Why create the entities in the weeks when Daniel was known to be gravely ill and had already begun consulting an estate attorney? He was aware of the plan, Marcus said. Do you have any documentation of that awareness? Ellen asked. A pause. The kind that fills a room. It was discussed verbally, with no record. It was a private conversation between brothers. A private conversation, Ellen said, that resulted in $11 million leaving the estate of the man you were allegedly conversing with. 9 weeks before his death, with no paper trail, no board authorization, and no reflection in any Hartwell Capital record, while that man was dying. Silence. From across the room, I watched Marcus Hartwell's face. I had watched that face across dinner tables for 11 years of my marriage. I knew its geography, and for the first time in my memory, I watched it come apart. Not dramatically, not in any visible collapse, but in the small, telling ways. The slight loosening around the jaw, the eyes moving to his attorney, just briefly, involuntarily, seeking instruction. He had no good answer. There wasn't one. Victoria, seated behind her counsel, had gone very still. Her hands, which had been folded with such careful calm the morning she came to my studio, were now clasped tight, knuckles pale. Judge Alonso made several notes. She did not rule from the bench that day. The formal decision would come in writing. But when she addressed both parties before adjourning, her tone was measured in a way that told me everything I needed to know. The court will review the documentation thoroughly, she said. The executor's accounting will be accepted into the record in full. I sat very still and breathed. Judge Alonso's ruling arrived on a Tuesday morning, 3 weeks after the hearing. Ellen called me before I'd finished my first coffee. I was standing at my kitchen window watching the first real snow of the season settle on the street below. Fine. Steady. The kind that sticks. Pepper was watching it too, pressed against the glass. It's everything, Ellen said. Complete. I sat down at my kitchen table. The ruling was 42 pages. Ellen walked me through it over the phone while I made notes, but here is the substance of what Judge Alonso had determined. The 3 holding entities created by Marcus Hartwell were ordered dissolved, and all assets, $11,300,000, were to be returned to the Hartwell estate immediately. The court found that the transfers had been made without documented authorization from Daniel Hartwell or any duly authorized Hartwell Capital officer, and that they constituted an improper transfer of estate assets conducted while the transferor was known to be incapacitated. The ruling further referred the matter to the Cook County State's Attorney's Office for review of potential criminal fraud charges. Marcus's 2 motions challenging my fitness as executor were dismissed with prejudice. Victoria's petition to override the will on grounds of undue influence, a challenge filed, we later learned, the same week I'd signed the executor papers, was denied in full. The court found no evidence that Daniel had been mentally incompetent or improperly influenced when drafting his will, and considerable evidence that the will had been prepared with deliberate care over several months. The foundation was ordered to proceed as Daniel had specified. I was confirmed as executor, with my full authority intact. My phone rang for most of that morning. Ellen, Patricia, Karen, Diane, calling from Minneapolis with what sounded like tears in her voice that she would never admit to. Even Richard Cole's office called, professionally, formally, to confirm the court's decision and inquire about my timeline for completing the estate administration. I answered every call except one. Marcus tried to reach me at 11:14 a.m. I let it go to voicemail. There was no voicemail. The next 3 months were the most demanding work I had ever done. Being executor of a 63-page will with an $11 million asset repatriation, a corporate foundation to establish from the ground up, and 2 hostile parties who had just been handed a devastating legal defeat was not something that could be done quickly or carelessly. But I had Patricia for the numbers, Ellen for the legal scaffolding, and Richard Cole's firm, now fully cooperative with the legal uncertainty resolved, for the estate procedures. The Daniel J. Hartwell Charitable Foundation was formally incorporated in February. Its focus, as Daniel had specified in the will in surprisingly specific detail, was workforce education and vocational training for first-generation college students in the Midwest. When I read those specifications for the first time, back in October, they had surprised me. I hadn't known that side of him still existed, but it had, apparently, in whatever form it takes to write it into a will when you are running out of time. I found in those months of work that I understood Daniel Hartwell better as a dead man than I had at many points during our marriage. Not with affection. The wounds of that marriage were real, and I had no intention of prettifying them, but with something closer to clarity. He had been a complicated person who had done complicated things and who had, at the end, tried to make something right. I was not going to argue with that. The estate accounting was certified by the court in March, all assets properly identified, all transfers documented, all creditors satisfied. The foundation received its initial endowment from estate assets as specified, and on a bright March morning, exactly 5 months and 12 days after Richard Cole had first called my cell phone, the Hartwell estate transferred $77 million to an account in my name. I was sitting in my studio when Ellen texted me the confirmation. I read it twice. Then I set my phone down and looked around the space. The fabric boards, the client samples, the morning light on the floor, Pepper on his bed by the window. And I felt something that took me a moment to correctly identify. Peace. Not triumph, exactly, though there was some of that. Not vindication, though that was present too. What I mostly felt was peace. The kind that comes not from winning, but from doing something difficult correctly, all the way through, without cutting corners or making compromises you'd have to live with later. Marcus Hartwell was formally charged by the state's attorney's office in April with fraudulent transfer of estate assets. He resigned from Hartwell Capital the same week. His attorneys were already negotiating a plea arrangement that would likely result in a fine and possible suspended sentence, outcomes that felt, frankly, insufficient, but were what the law would deliver and not my decision. Victoria had not spoken to me since November. She had moved out of the Georgetown house, which was being liquidated as part of the estate settlement, and retained her own independent counsel. Whatever life she was building from those pieces, I neither knew nor needed to know. I closed the estate file on a Thursday in late March, set it on my desk, and let out a long, slow breath. Then I called Ellen and I said, "It's done." And it was. I did not, as people in these situations sometimes do, change everything at once. I had spent enough of my life in the company of people who mistook dramatic gestures for actual transformation. What I wanted was something quieter, something built to last. The first thing I did was finish my existing clients' projects, to the standard I had always kept. Then I gave raises to all 3 of my employees and sat down with each of them to ask what they actually wanted from their work lives. I had not previously had the margin to make good on what I learned. Now I did. I flew to Minneapolis and spent a week with Diane. We walked the north shore of Lake Superior, talking honestly about our childhoods, our marriages, what we were still afraid of. It was the most honest week we'd had since we were teenagers. I drove home feeling lighter, as though a tension I'd carried so long I'd stopped noticing it had finally, quietly resolved. I kept Meridian in company. People assumed I would sell, but they had misunderstood why I built it. Design was what I loved, and money did not change that. What changed was the scope. A commission restoring a 1920s building in Pilsen, the kind of work that asks real things of you. I made a personal gift to the foundation, unpublicized. It was about completing something, acknowledging that even broken people sometimes get things right at the end. Pepper and I moved into a house in Lincoln Square with a garden. I found that I loved gardening in ways I hadn't anticipated. There is something restorative about work where time and attention produce something visibly growing. As for Marcus and Victoria, Marcus pled no contest to fraudulent transfer. Suspended sentence, 5 years probation, civil judgment requiring personal repayment to the estate. Hartwell Capital voted him out. He sold his Gold Coast apartment and was last heard consulting for a small firm in Florida on a fraction of his former scale. The Golden Rooms had closed. Victoria filed a civil action against Marcus and was living in a rented apartment in Bethesda. I did not look further into it. Her life was her own to navigate. I won't pretend their diminished circumstances produced nothing in me. There was satisfaction, the quiet recognition that the world sometimes delivers proportionate consequences, but dwelling in other people's failures is its own kind of trap. On an evening in late October, I sat on my back porch with a glass of wine and Pepper beside me. The garden had gone bronze and silver. I thought about Daniel, not with grief, not with anger, with acknowledgement. At the end, he had made one choice I could respect, and that choice had changed the shape of my life. That was enough.